It's about 7:09 now. We do have a quorum. However, we are short two of our three permanent members, so we need two temporary members to step up, or associate members to step up.
I volunteer.
Lee volunteers. How about you, Leah? You want to join as a voting member tonight?
Sure.
You heard the first session of it, so you are qualified. Right, Woody?
I did.
Yeah. Okay.
I can join, absolutely, as a board member, that's okay.
Okay, we have one continued hearing tonight, and it's 20 Pleasant Street. The applicant is Chris Ford. It's an ADU special permit. The use is not subject to any kind of, it's a use as of right. But there is a special permit on a couple of alterations. So, Chris, do you want to just give us a quick review?
Well, as you said, with this being not in my mind, it's reality. Question, not whether.
Chris, can you first go up to the podium? There's a mic up there.
Purpose of the meeting is that we wish to add a dormer and we call it a bump out closet on the rear of the building. And that requires the special permit. The ADU has been granted as a matter of right. So that, as you just said, that's not the unit. So we've had no objection to the request for a dormer. Some issue was raised, well, I had a conversation with the neighbor about it. And he had no objection because it was not facing his property. And it actually is facing no one's property except the 5-unit building that is adjacent. And as far as, well, I don't know that I have to really bring anything else to the
No,
equation.
that's fine. I just wanted a quick summary.
Okay, fine, thank you.
Does anyone else like to speak? Any comments?
Yeah, I had questions.
Need your name and address first.
I'm John Short, 30 Pleasant Street, Cohasset, neighbor to Chris. I had questions. I was curious what the process is of getting an ADU. So it sounds like the ADU has been approved, but sure.
It's not,
ADU, the zoning board, the community authority, the ADU, it's already a by right use state. So essentially, it's a apply for a permit, then they need to produce the proper functions, fire safety, building codes, bathroom, all those need to come with a dwelling unit. And allow to separate it from property, so the process is building permit.
Okay.
essentially what our role is here, the state passed a statute to encourage ADUs. So at the last town meeting, we had to conform our zoning bylaw to the state statute, which made this type of ADU a matter as of right. The landowner can do it. The reason that we're here is because to put the dormer in and the little piece on the back, it increases an existing nonconformity, which requires a special permit. And the standard is we have to weigh and determine whether or not that increase in the nonconformity is substantially more detrimental to the neighborhood than the existing state of affairs. It's not the use as a dwelling that's before us. It's just the change in the structure of the building in the nonconforming area.
So would the bump out be, like, would it increase the footprint of the ADU?
Yes.
Okay. Okay, because in the last meeting, I thought we had discussed that the bump out was not extending the footprint of the ADU, and therefore it was within the law for the ADU to move forward with that bump out being added.
And that's why they're here. Is it more detrimental than to the neighborhood than what exists or not? Not that it is there more footprint, but is that increase in footprint more detrimental to the neighborhood?
Well, my understanding of the law is there's setbacks
There are.
that are required if there's going to be an expansion of the footprint of the ADU. So right now, and I'd gone on the site and tried to email someone, I did not hear back, but I emailed today and I wasn't able to find any of the board members, so I apologize. But I had been curious because there's about 12 to 18 inches between our property and this ADU. And so there have been concerns on my part in terms of the impact that it's gonna have on my property and, you know, obviously his ability to maintain the property. But my understanding, like last time when we had come up, I had been told that the bump out was not going to extend the footprint, and thus the ADU as it existed today would not be a part of the setback laws that are required in the state, my understanding, or in the town, which I understand is to be 5 feet. And so I'm curious that.
Extending a nonconformity or increasing?
It looks to me like it's
Exacerbate.
extending.
What? Extending?
Yeah, it looks like it's extending and it's within the beyond the 3 foot back. But within a 5. Because it's less than 15 feet in height. Give us a minute. This is new to us too.
Okay. Yeah, me too. I mean, my understanding was that, you know, there's not a lot I can do if the shed is an already existing structure, no matter whether it was 6 inches, a foot, or 18 inches. My plan was to come here and ask today how that worked as it pertained to maintenance, but understanding that we are putting addition onto the existing structure, I think that.
Could you, for my benefit, and maybe I'm sure the boards, could you explain or help me understand how would the maintenance issue, how would maintenance be impacted by this either bump out or height?
Well, there's only 18 inches between the property, between the ADU and our property.
Right, which exists today. So if they were to add this little utility area, how would that impact the ability to maintain it or impact your ability to?
Well, so I recently acquired the land, and so I'm curious to understand my rights in that situation and you know, the different opportunities that I have, and figured this was a good place to come for that.
Yeah, it's just that you've got to help us a little bit here, because I'd like to understand how the maintenance issue, if that's your concern, is made worse or more difficult or problematic, whatever word you want to use, than what exists today.
Well, I think a dwelling is treated differently than a shed, right?
Go ahead.
Two things that will take place, due to the proximity the 18 inches, they will, on the side that faces you, will have a fire resistant material. So that will be installed, but pump out or the utility closet is further away than the 18 inches, so they won't need to be, that will all be accessible from their property. But again, the existing in the dorm will also have a fire rated material on it to protect the property line because of the 18 inches. But that's in the building for the so
Okay, and is that already on the property or are they going to be? putting it there?
that will be a requirement.
Okay. And would someone ever be able to put a window on this side of the property?
I don't believe they have one on it. And due to the fire, they won't be able to get one on that side.
Okay,
On the part that's close, not the part that's far.
right. So because they don't make windows that are fireproof or something like that?
They do, but they're just very expensive, so.
You'd have to get like bulletproof glass or something like that.
Yeah. But again, the rear portion of the structure is where the 18-inch occurs. Front portion side does not have, does not require the setback in the little more property, it's a little jog property. So that 18 inches where it's close to in the rear, you won't be getting.
Okay, all right.
So again, this is special permit to extend an existing nonconformity. If it was to create a new nonconformity, it would require a variance and probably wouldn't qualify for variance. It's a different standard. But what we have to weigh is whether it's substantially more detrimental to the neighborhood than the existing conditions. So that's what we need to weigh. If you have any concerns about, the law is, it's not just the neighbor, it's the neighborhood. So if you have particular concerns about substantial detriment, please tell us.
Okay, but my understanding was with the state law, if you're changing the footprint of the shed, that the setback law is required to be at the minimum set by the municipality, which I think is in Cohasset is 5 feet. Are you saying that it's not technically an expansion of the footprint?
It's not, yes, it's not. It is technically an increase in the footprint, but the footprint is already non-conforming. You can increase the non-conformity with a special permit. You can't create a new non-conformity without a variance. So it's kind of a weird thing, because if you have a conforming building and you want to add something that encroaches a little bit into a setback, can't do it. If you have an existing building and you want to encroach into the setback on an extended part that's already there, you can do it. I know it doesn't make a lot of sense, but that's what the bylaw is.
I mean, I hate to say this, but I will anyway. If a non-conforming building has certain rights that a conforming building doesn't, that's counterintuitive. But that's the way the law
What
is.
is a non-conforming building?
Well, you've already got a building that's in the setback, right?
But is it like a shed or a garage, or is a non-conforming building like a structure that
Structure.
exists? It could be a house, it could be anything. Okay,
And this is, because this is an ADU, and an ADU can be put in any pre-existing building, whether it's a residence or not. Which is a little different than what we normally run into.
yeah,
Yeah.
yeah, I took a weekend to learn the
ADU.
law a little bit. And I mean, my concerns are not with someone like Chris Ford building it. My concern is, one, you know, there's nothing personal here there, but it's 18 inches over the property. And,
Right.
you know, this is an area that's important to me and my family. And for the sake of Cohasset moving forward, and I've emailed Maura Healy and Patrick O'Connor and let them know, I think that the ADU law should be adjusted, and Patrick O'Connor has said that he's filed an amendment to change the way the law is structured to enforce primary residence owner occupied homes. And I think that's smart. My concern is we have companies like Blackstone who are investing or who are buying up 23% of real estate. And this gives institutional capital an unfair advantage in acquiring homes because they're able to acquire a home that they can see 10 to 20% improvement in income that they're gathering from these properties. Where I'm still going to be getting a mortgage based on what the bank is willing to lend me. And so, you know, my hope in coming up here tonight was that we can, and I don't understand the municipal process, but my hope was to come up here to talk about that and just, you know, voice my concerns and hope that Cohasset in some ways can push back. I don't think it necessarily would be fair to do it in this situation. But longer term, we look to work with the state on ways that we can stop this, because I think it's a pretty broad law. As we can see, they're 18 inches over the property line for me, and you know, he can build, and I don't know what Maura Haley is going to do in the future, but it feels like a really difficult law for residents. I think 18 inches is unprecedented in terms of allowing someone to live that close to the property line. So
I think you're approaching it in the right way. Your elected representatives are the ones that make the law and can amend it. And you can get attention there and enough, you know, kind of compatible thinking, they can make a change.
We
You're
can't,
doing it the right way.
we can't amend the state law.
yeah, I know.
Here.
I know.
But we, you know, one thing we can do is if something actually is substantially more detrimental to a neighborhood, we can deny a special permit. And we will. But this probably doesn't quite approach that. Anyone else have anything they want to add, comments? Anybody on the board? Anybody on Zoom? No. Do you want?
My wife is on Zoom, and she said she'd vote for me.
Okay, we'll let her know.
All of his grandchildren too, and his sons,
Well,
they're all in support of you.
I want to assure him that this property is not going to change hands. Blackstone isn't going to buy it. And I've already drawn up my estate, and I'm leaving it to my 6 grandchildren with instructions never to sell it. Because it's, you know, I've learned the value of real estate over the years myself, and I want them to appreciate it.
Yeah.
So,
And my
concern
is not you selling it, Blackstone. It's the,
I'm willing to write bloody.
No,
I will put a window on that side.
my concern is not about this individual situation. I want to be
I know.
clear about that, not attacking you, it's that
I appreciate that you sent me a copy of the letter, because I agree with almost all. You're right, you're on the right track.
Yeah.
You've raised
Yeah.
some legitimate issues, and I think it is. Well, yeah. But at the same time, I'm in favor of the AD, the one, I'm glad that came to Cohasset. I learned about it while I was trying to convert this, as John knows, into just kind of an office for myself. And then I learned that the law had changed in Cohasset, and I was now eligible by right to have an ADU. And I think that's better for me because it's a part of my income, and it's better for my grandkids because they'll have a property that's just a little bit more valuable. We right now have 5 tenants, 3 men and two women, and I don't think you have to worry about rowdy tenants during our ownership. No one's ever, the police have never been there, to my knowledge.
And gets the gasoline powered stuff out of the shed too. The motion,
Motion to close the hearing?
is there a second?
Second?
All right,
Sure.
it's been moved and seconded to close the hearing on 20 Pleasant Street. All those in favor, David Morris, aye.
Lee Darcey.
Leah Fernandez, I.
Richard guy.
All right. Hearing is closed. So the next item on the agenda is deliberations of any closed hearings. We have one, 20 Pleasant Street. We have a draft decision, which I found to be complete. And I don't have any suggested changes except to add tonight's input. Anybody else have comments?
Yeah, I was gonna make the same comment about dating it for tonight, so.
And I would love to,
You're gonna have to change Charlie Higgins.
Right.
Yeah.
And Matt Watkins.
Oh, that's-
if you could figure out how to email us the letter that you said that you copied him on.
Did you maybe get
It would probably be helpful for the addition to
Oh,
the.
no, you pulled something up, I thought. maybe-
Oh, it was a,
No.
Well,
It
you
was-
can always email Julia,
Yeah. I'll-
and
yeah.
then she will
She
get
gets them
into
out
it.
to us.
That's
Yeah.
actually the best way, instead of sending it to us directly, to send it to Julia, and then she sends it out to us.
Okay.
Do you have her contact?
Yep.
Great.
that's all.
Okay,
Perfect.
yeah, that's the way.
all right. Have a motion on the decision?
Motion to approve the decision as drafted with amendments, the suggested amendments.
Second?
Second,
All right, all those in favor, David McMorris, aye.
Lee Darcey.
Leah Fernandez, I.
Okay, Woody Chitta guy.
All right,
My vote doesn't count for much.
I know, but we like to hear it. All right, the next item is the meeting minutes of September 8th. Thank you.
Thank you for
For your-
coming.
Thank you. Thank you.
Thank you.
I didn't have any changes.
I have none either.
No.
Motion to
Motion
approve.
Approve the minutes?
Want a motion to
Yep,
approve the
I
minutes?
do.
The minutes are great. I didn't see anything.
Okay. Motion to approve the minutes of September 8th.
Second? All right, moved and seconded to approve the minutes of September 8th. All in favor, David McMorris, aye.
Lee Darcey. Aye.
Leah
Woody
Fernandez.
Chitta guy.
All
There we
right,
go.
minutes. And the last item on the agenda is our next meeting is October 27th. And my understanding is we have 3 items on the agenda. There is the application on the Elm Street property, and there are 2 new ones that Julie has received recently.
It's the dock.
Okay, and Joy Place is the dock,
Dock.
and Whole Street is,
And it's a large ADU. What, where is that in here? The
The
large
ADU?
ADU, the large one. I mean, I have it, I have the definition.
149.
it's,
149 to 151. I don't know the numbers.
Oh, no,
Oh,
the
the
section,
section.
not the address, the section.
I think I heard you right, it passed, right?
Yeah.
Yes.
Okay.
you're good. You'll get it in the
4.3.
mail in a few days.
Yes, good.
When,
Okay.
when you're winning, you don't want to keep arguing.
No, okay.
You want to
Shut up, right?
get out there. out there.
Well, Nancy said, Chris, just stand up and say nothing.
Good advice.
Good advice.
Nice to see you.
See you, Chris.
Bye-bye now. Okay, this is 4.3. And that's for the large.
All right, here we go.
Okay, it's 1.1, 4.3, 1.1. At the bottom of the page, okay.
That's the 950 to 1250.
Yeah.
Mhm.
That's here.
Okay, and this is a owner occupied. One of them is owner occupied.
Single family dwelling. I don't know if it's owner occupied. That would probably be.
We'll find out.
I believe it's all.
It says, well, it says the owners of the subject premises must live in either the principal single dwelling or the ADL as their single dwelling.
Yeah, in the state, the.
You want
It has to
back
be-
the page?
Oh, no, I got it.
Single family.
So our bylaws are not quite in sync with it.
Yeah, it's awful. Because it's so in single family.
Yep.
That's what makes it wild. If it's a two family, but it's still zoned. Single family. It's allowed. in the state.
But in a large ADU,
Large ADU still has to have a special permit approval over. Over the.
950.
The use is still allowed. All you guys have to say.
but it also has to be owner occupied, one of the, either the principal dwelling or the ADU.
That's not what John
Not
said.
according to the
It's
same.
saying,
So
our bylaws.
I
says
thought
that,
this,
but
isn't
it's
this the
saying
updated
state.
bylaw?
The updated bylaw probably got 98% of it, right, but that portion of it they missed. It was written in the state that if it was, like if it was a business zone, it wouldn't.
You know, it
Right.
would probably help the board as we kind of consider this 27th meeting to get that section of the state law
Okay.
that
Yeah.
would kind of override the town. I mean, I certainly don't think we want to
No,
hang our hat.
The
What?
Attorney General approved it. Right?
Yeah, but they might have approved it for the state bylaw. Remember, there were iterations of the state bylaw.
yeah, and I just been to a couple seminars and the attorneys that spoke that the way they interpreted it from the state was that they if it was zone single family, that's what the exception. The area was zone single family, then it would have two family. Even that it was still zone that.
You raise a good point, but at the either the most recent town meeting or the one before that, they did, Tom Callahan and company did come forth and say, we're updating our bylaw
Mm-hmm.
to comply with the latest state. And I don't know if that update got approved by the Attorney General's office, right?
I'm not sure if it did, it was. We did get an update just about 2 weeks ago. Something that came through.
Double check, but I know it's the latest one. It's on the website, but I think, I didn't hear anything like, no. But it had notes, I think, there were notes from the Attorney General's office.
I'll reach out. Really like to reach out. If it's a section.
August 25th.
State.
It might have been considered an administrative housekeeping kind of issue that didn't require a full, review by the AG. I don't know.
Right,
I mean, there was stuff coming,
I know, they took their time looking them over and proving them.
yeah. I'm wondering, though, it might have been that the state approved their bylaw as it was originally written and didn't approve any of the corrections or. I don't know. Lawyer, I mean, I'm not.
I don't know what the statute says, but I do know what the bylaw says.
yeah, but at least we can get them all together.
You could necessarily get a town council opinion.
Yes.
I'm sure
Since-
she would say, apply with what the wording of the state law, not,
Yeah, but that way we can have the verbiage
yeah.
go along.
Well, also, the next meeting, the town council is gonna be
Here,
on the meeting.
Yes.
Well,
But I'd give her a heads up.
she's not, according to Julia, she's not coming.
It might be just,
And he'll be remote, right, correct?
there is this
Okay,
kind of imbalance.
Yeah, I think she's having, is it Justin?
It's just,
Yeah.
Justin, I mean, we were on that meeting. With him for 91.
so that would be good for us because we'd have town council on to kind of tell us about our zoning reg. Which now we can't get on the warrant for the next meeting if we have to check it. Change it. But ultimately, it has to conform to the state regs regardless of what is in our zoning regs, right?
Right, I think they, but
Yeah. Yeah. And we don't want to get into withholding of grants and all this other stuff. Milton Township.
and we just have to find out. What, I believe it read zone single family, that's. Oh, no. That- that double check.
Do you anticipate a number of ADUs?
There's probably 6 other ones that are kind of,
Working their way.
yeah, some of them are. One, would be a matter of right, the setbacks at the parking, it's basically a basement. Which is the second means of egress, the architect separation. So that's. There's no. Or a building permit. We also have to keep track of them from the state. Permit date, you know, and occupancy date, and that stuff, so we have to kind of track them. So, but also with the new town bylaw with the apartments, we expect apartments annually. So that the ADUs will go on that, we expect the annually ones to also.
That sounds like a lot of inspection.
It is, a lot of the apartments, outdoor, a couple of most of the time.
What about Chris Ford's apartments?
Yeah, you know, you get a letter, so it's $75 a roll. And it, on South. There's more than you think kind of scattered throughout town. Here it is, so it took about 6 months to assemble this. And some people say, no, we don't. Without, just kind of follow up. Try to keep it active.
According to Chat GPT, we can't restrict owner occupied at under 900 square feet. But if it's if it's over 900 square feet, the municipality can impose more restricted requirements. Doesn't say for sure whether it can be owner occupied or not, but over 900 is not, under the state's definition, a protected use ADU.
Right.
Huh.
Protected use or protected square foot.
Under 900 square feet is a protected use ADU, and we can't really impose anything other than, you know, what we did tonight with the further encroachments in the setback. But according to this, if it's over 900 square feet, it doesn't have that same protection. And we can impose more requirements than the smaller one.
But it doesn't define what more requirements would mean. It sounds like,
Does that apply to the part that's greater than? No, you know what I mean?
yeah,
If that's the portion that's in the setbacks. Or, so. It does get old.
I don't know.
You know, I think you look at parking, you know, because of the size, and extra space, or those type of things, or.
Yeah, I think this needs town council's input even more than Chat GPT.
Although I'm impressed.
I don't, obviously
He's not that old.
can't use it for, arriving at real conclusions, but I find it to be very helpful. Point you in a direction. Where to find stuff. Oh, we didn't adjourn yet, did we? Oh. Okay, so we have the next meeting is 27th. So anything else anybody wants to add? All right, move we adjourn.
Second,
All in favor, David Morris, aye.
Lee Darcey.
Leah Fernandez, I.
What did you?
All right.
There was one other